The thing that I thought was missing, that I was surprised you didn't sort of use as the key anchor to all this, were debates themselves over the idea of representation itself. It seemed to me that the primary mechanism of accountability, the master concept that really runs through 18th century Anglo-American constitutional argument, is over what constitutes legitimate representation. And the Federalists and Anti-Federalists disagree in a pretty pronounced way on just this question. And I think this then falls along sort of two separate axes. On the one hand, they have two very, generally speaking, different working ideas of what constitutes a representative. Federalists are much more of kind of a model of agency. You have chosen somebody somehow. Anti-Federalists, it's not a question of how the person got there. It's a question of whether they are a representative. They represent you in some meaningful way. In a pictorial sense, they mirror you, they capture you. As Brutus famously said, the representative is the sign, the people are the things signified, right? It's that even if you've elected somebody, if they don't share your sentiments and interests, they can't be your representative. And then from there, a lot of what Anti-Federalists begin saying, I think, and a lot of what you talk about here in the Virginia debates about accountability, I think this is really important because it's entangled with this concept. What they think about representation in the state constitutions no longer applies precisely because their fundamental indictment of the proposed constitution is it cannot be representative. It doesn't have the proper mechanisms in place to represent the people accurately. So you need different kinds of accountability mechanisms to make the best of this system that otherwise is probably going to be terrible. So a lot of what they're talking here is a direct byproduct of having reached this first conclusion, I think, that this government with a House of Representatives that will only have 65 members, one for every 30,000, that can't be representative. So the basic measures of accountability that actually have worked and have worked at the state level and that we figured out and we solved between 1776 and 1780, those are no longer on the table. So we now need to argue for a different set of things as kind of a second best solution. But that's entirely entangled with working ideas of representation that I think are kind of the core accountability mechanism that I would really encourage you to kind of anchor the paper with, if possible.
John?
So I want to pick up on Will's Fourth Amendment point briefly. The Fourth Amendment, even internal to the ratification process, the ratification messages proposing bills of rights wanted to include some kind of search and seizure provision to cut off the possibility of a federal statute, giving in effect absolute immunity to federal revenue captains. Everybody knew the new government was going to rely on impost duties and excise taxes to finance itself. There was going to be smuggling, there was going to be enforcement. We were going to have the same kinds of problems that we had with writs of assistance. So those ratification messages presuppose the possibility of suing federal revenue captains either in state court or in federal court for trespass or conversion or whatever the appropriate form of action might be. And then if you want to broaden the perspective just a little bit beyond the ratification process, early on in the first Congress, there are statutes, and Fabio Arcilla, A-R-C-I-L-A, I don't know if you know this article or not, but he has an article where he goes through and traces the procedural provisions in the early revenue laws that tweak the procedure for trying these cases, these tort suits against federal officers. Some of those provisions are very pro-defendant provisions. They're not absolute immunity, but there are double and triple cost provisions for recovery against losing plaintiffs. There's a provision which says that the captains can plead the president's rules in defense. And so those really press the envelope of just how far can you go by way of preempting state tort remedies against federal officers, and a long look at those might be very helpful to you. The other thing I have is completely off the Fourth Amendment chart, and maybe off the wall entirely, but if you go to Murray's Lessee against the Hoboken Land Improvement Company, the backstory to that case involves the irrepressible rogue Samuel Swartwout. Yes, that's Swartwout. And he was the collector of revenue for New York under Andrew Jackson, and was then ousted by Van Buren. And the Van Buren administration, there was personal animosity between them, and Swartwout was found to be deficient in his accounts. And since he was fleeing to England after selling off all his property, they had a problem with that. And in that particular, in the Supreme Court case, the Curtis opinion goes through the English procedures for distress remedies, very muscular forfeiture remedies, against officers who had been found deficient in excess of their bond. And so I have not verified Curtis's citations, but he says that that distress warrant remedy goes long back into English history, and that might be another fertile vein to mine.
Okay, Jennifer, I love this project. I view this as a piece of your bigger project. I want to sort of pick up on your suggestion, how much of a normative piece is there, how much of a normative piece should there be here? And I wanted to say, in thinking about that, and also thinking about the theoretical framework in which the normative piece is articulated or would be articulated, it strikes me that there's a lot of sort of structural reasoning here, that you're sort of taking an originalist sense of the operation of the constitutional structure, and that would then build into a normative argument if you start to build it out. So I'm wondering, as a sort of a theoretical question, at what level of generality ought we be articulating these structural concerns in these sorts of areas? At a narrower level, we could say our structural concern is accountability of officers, and when you get to sort of Will's first bucket and democratic accountability, that can drive us in a certain direction. But if we step back more broadly, we might suggest, if the normative piece ended up, say, imperiling the administrative state, for some people there's a functional risk of that in terms of the success of the American hegemonic project in the 21st century, or for instance, if we can't have an independent Fed anymore and presidents can manipulate the economy in the short run in anticipation of elections, in theory that could be destructive of the country as a whole. So I'm just sort of wondering, the farther back you step, you may get different answers than the narrower you go. And if we're walking back from text a little bit and more into abstract structure, how abstract do we be and how do we think about that?
So thank you all. Although that's very, very helpful, and I appreciate the ideas of further things and themes to discuss and further research sources. Tom, I mean, that is a challenging question, obviously, level of generality. And I mean, I think one reason why it's even more complex, obviously, is because if you're somebody who believes that practice has veered off course in multiple different ways, then, it's almost like one error sort of makes the other error much more vast. So, for example, if one believes that the federal government right now is just doing too many things, so a fundamental commerce clause violation, obviously that might make all of the other structural things not work the way that they were intended to work. So my inclination there is to say I don't know that I don't know that this paper would necessarily be able to precisely address that, which is why I'm more inclined to say, to have the bulk of the paper be to present, this is the story of what it seemed, how they seemed things would be understood at the time. And then in identifying specific modern practices or structural systems that we've grown accustomed to, talk about ways in which possibly it could veer away from the understanding of the ratifiers, and perhaps in doing that analysis, I could acknowledge and specify at what level of generality I'm talking. Because obviously, we don't need to do things precisely at every level the way that they were done back in the 18th century. But I'm hoping that this piece will at least give a sense of what they thought the core required structural principles were that needed to remain in place. And it seems to me that at least some of the ways in which we have veered off the track in those areas today are fairly straightforward, but maybe, as I say, maybe in coming up with a couple of modern applications, I can just highlight the difficulty there and talk about, based on the level of generality one chooses, what the different application might be. So I appreciate that question.
My next threesome is Mike Ramsey, David Upham, and Bill Trenner. Mike?
All right. Well, thanks a lot for the paper. It's really interesting, and I wanted to ask about the methodological assumptions or background behind this, and sort of picking out the ratification, not really just the ratification debates, but the convention debates as the focus, and I'm sort of wondered what perspective you came away with from that. It's because it's not sort of your typical originalist paper sort of goes through, well, you got the convention and so it goes through the whole thing. I'm sorry, I should have talked about the text there. So it sort of goes through the whole you kind of know the iteration you're going to be looking at, but you're just singling out this particular piece of the puzzle, which is fine. I'm not challenging that, but I am wondering what you come away with from doing that, and what the justifications for generalizing from that are. I mean, and a couple of times you said sort of this is we're learning what they thought, can we say that? Because I always find that the ratification, the convention ratification, is sort of frustrating because on one hand, we don't have all the complete records, as you said. You talk about this a little bit at the beginning. We don't have all the complete records, and I also find that some of the things that people say seem to make a whole lot of sense, and I'm sort of nodding along with it, and other things people say seem to be really sort of wacky. But then I don't know when I'm looking at something that's wacky, I don't know whether I'm looking at whether it's really wacky. I mean, wacky at the time. Or does it seem wacky to me because I'm not understanding what they're saying because I don't have the background? And so all this is kind of leading me up to to ask sort of what your reaction after being immersed in this project is. Do you think that the ratification conventions provide sort of a coherent record of what they thought? Or are they just sort of scattershot of what some people thought, some of whom may have been thinking with their heads straight and others not?
David.
Yeah, I thought this was. I thought it was excellent, and I think the focus, in my opinion, I think the focus is appropriate because the ratification is the only. The Constitution is unauthorized. The Convention, excuse me, is unauthorized. But the ratification is the purported to be the formal act of the people to ratify, and focusing on this and placing it in terms of primacy, I think is appropriate. And that's also what's new here, to place this in a single article, or I would say hopefully a longer article. That's it's not even if you're just simply speaking on popular accountability. Yes, you're not learning something new, but you are learning that at sort of what arguably is the most critical moment, these themes and these principles are being emphasized. A lot of the comments that Will made, I was also making, and some of the others, the popular accountability. Yeah, I think that should be distinguished from the accountability to individuals harmed. And that would be, so you wouldn't say individual accountability, you'd say accountability to the people directly or indirectly. That would seem to be more consistent the way Madison phrases the whole Republican government thing, directly or indirect. Representation differently, and then also, that issue of the non-delegation doctrine, that even officers that are thoroughly accountable in all the right ways, they do not represent the people. They are agents of the people, but they cannot. They don't have sufficient representation to exercise the big fiscal powers that only the House and lawmaking powers that the House of Representatives should. And then I'd maybe consider right now, based on what people said, at least four different things: representation, popular accountability, individual accountability to those harmed, and then lastly, the way religious motivations, and I would also say just public honor motivations, are behind oaths. Not wanting to look stupid in front of your friends, even if you yourself don't believe in God or anything.
Bill Turner.
I think this is it's fascinating, and I also want to say, how impressed I was by your Stanford piece as well. And, this is a great following through on a lot of those issues at a different level. The one thing I wanted to ask you about is, I think you do a very nice job in talking about how important accountability was to the ratifiers. But I think they also had, what I want to suggest is, I think they also had other values. And so, for example, I think accountability was important to them, but so was efficiency. So for example, I think, the Articles of Confederation where, you really, basically everything is done by Congress, and only later do they kind of move in a very limited way to, a bureaucracy, but it's really Congress is doing everything. That's really maximally accountable, right? But they move away from that. And, and similarly in the early state constitutions, a lot of them have very short terms of office. In a lot of ways, the Constitution is moving away from that kind of strong accountability and recognizing, the importance of efficiency as well. So again, you see it moving away from just total legislative dominance to a stronger executive. You see it in, the Senate having 6 years as opposed to kind of 2 years terms of office, which I think makes them less accountable. And then I think, this is outside of the confines of your paper, but there are also some of the early appointments that I think are at odds with the pure accountability theory. So for example, I think this is right. I was just checking. This is from memory, but I think this is right. The U.S. attorneys were initially appointed by the courts rather than by the attorney general. But the larger point that I want to make is I think that there are other values other than accountability, and that you should be kind of taking account of them and thinking about how they influence the shape of the appointments clause.
Jennifer.
So thank you very much. So I appreciate all the comments. Maybe I'll start with Bill's first, since it was more recent. I don't think the U.S. attorneys were appointed by the courts. I'd have to go back and double check, but I'm pretty sure they were appointed by the president. I think that it was deputy marshals who might have been removable by the court. But I'm pretty sure in the early practice that the only folks who were really appointed by the courts were the court clerks. But I recognize your larger point about how, and I think what you're saying, correct me if I'm wrong, is that you're maybe encouraging me to look back beyond the ratification debates and do a little bit of compare and contrast and look back to how accountability worked perhaps under the Articles of Confederation and just acknowledge the distinctions between the two governing laws, and in doing that be able to identify that we're not totally moving in a pro-accountability direction, but there might have been some move toward efficiency as opposed to accountability, to make sure that it's more completely accurate and descriptive and not suggest and not in a misleading way suggesting that accountability was the only thing that was going on in terms of their creation of the governmental system. And I think that's a very good point, to go back and just look at the major distinctions between the two governing documents and try to distill what those would have been and just acknowledge that up front in the paper. Mike Ramsey, I appreciate your point. I definitely agree that this is sort of an atypical piece as far as originalist methodology. I mean, part of my thinking there really was just initially I was sort of setting out to clean up from the Officer of the United States piece and just really discover that at the ratification debates they're talking at such a high level. I mean, I guess the earlier paper was complete in the sense that there's not a whole lot of discussion here of the appointments clause itself. In fact, most of the references to officers here, because I thought it might be another word study just on officer than in the ratification debates. And officers, they're just talking about, for the most part, elected officials. So, but as I started reading through, noticing all these other interesting themes that I think do kind of build out and give some larger context for some of the claims that I make in the appointments clause paper. So I think to the extent that this is a legitimate project at all, I mean, I think that it's my personal view with that it would be at least legitimate as far as a descriptive matter, like this is sort of a cohesive source, and this is what these set of people who, for certain reasons, some of us at least think might have had relevant things to say, this is kind of the general debate or level of things at which they were discussing issues. This is the range of views that they would have had, and kind of put that down as a marker and possibly contrast that with what we have today. And I do think that can serve some use as a descriptive matter. I do think I would get into trouble trying to just make too many claims that this set of debates shows that we must do A, B, and C today. It might just be one piece of evidence that suggests we've sort of shifted our discussion. I mean, and as far as building out and using the other sources, I mean, because my piece is not focused on one particular provision or constitutional principle, I mean, I don't even know how one would approach doing a thorough, like, original meaning analysis of a more fuzzy theme like government accountability, right? Because I'm, like, touching on, I think, as Will said, maybe 10 or 15 or 20 different government principles, and so to try to do an original meaning analysis of all of those things would just sort of be probably even more than like a career's worth of work. So maybe the way to handle it is for me just to be even clearer up front about the limits of the claims. And then to your point about how do we know how wacky somebody's statement is, I mean, I think the other point is how would you ever know if the ratification debates were going to be dispositive because they were the people who brought the Constitution into being. What do you do with the people who voted against it, right? Like, would you go through and say, well, I'm going to handle their statements differently because they didn't end up supporting it than somebody else? Those could all be challenging questions, again, and I think I just need to handle that by maybe more clearly acknowledging it and just putting some limits around and saying, I'm really intending this to be quite a different project, more of just a narrative kind of summation type of project than the officers of the United States work. We'll be filing government briefs based on this or anything like that.
I have Larry Alexander and Richard Primus next. Larry?
Yes, Jennifer, there are lots of things in the paper. The thing that really caught my attention, so this would be a very retail comment, is on page 23 where you talk about the use of state officers to perform federal functions. Of course, this brings up, today we think about the commandeering and unfunded mandates and things of that sort. But it's interesting as an accountability thing, because if you're a state officer, your primary accountability is not to the federal government whose function you would be carrying out, but to the state government whose employ you served. And so, and it was interesting that I don't know how representative, Governor Randolph was of because he's the one quoted here as, recommending using state officials to collect federal taxes. But, so, this may be one of Mike's wacky, off the wall things. But it's an odd kind of accountability thing. If you're worried about how the federal officer is going to be accountable or how the officer is going to be accountable for fulfilling the federal function, it just seemed somewhat odd that they would recommend. So what they seemed to be concerned about was protecting the states against overbearing federal officials, and therefore employing state officials would somehow take care of that. But of course, today we think about that as impinging on state agendas and state budgets. So I just want to, it doesn't fit clearly into the accountability story, because it's kind of it seems to want to put accountability someplace else other than accountable to the federal function that's being employed.
Richard.
I'm glad that you said what you said a couple of minutes ago about thinking about whether and why you want to differentiate between supporters and opponents of the Constitution. Because one of my dominant reactions reading, this is just at the level of the descriptive history part, was that I kept hearing from people who were very opposed to the Constitution. Like Patrick Henry has a starring role in the draft that we have. And when I read that, I thought, and here this goes to something that, that Bill mentioned, because it's easy to see the Constitution as a move to make the government less accountable in a politically accountable way, maybe not in the legally accountable way, right? We have a federal judiciary now, right? But in the politically accountable way, we're making this thing much less accountable than it was before. And here you give us Patrick Henry saying political accountability, and the lawmaking process says to him, Mr. Henry, we hear you, you lose, big, right? I want to encourage you to think about, right, what might be the upshot from the people you're giving us based on their views of the whole project, plus or minus. And then I think there's an opportunity here for you, if on the normative side, either you're going to discover that the ratifiers had a thick theory of political accountability, or maybe you'll discover that in Will's two categories, they are trying to substitute away from political accountability and toward legal accountability or some other such thing. There's an opportunity for you to think about the plausibility of the political accountability theory in a system of the kind that the Constitution is building. Because it's building a government for a large polity. And in a large polity, if you have a government of any size, the idea that the president is going to be thrown out of office if he doesn't exercise his ability to remove, some officer somewhere, it's unlikely, right? I mean, there's the issue environment is so dense 4 years from now when the things comes up that probably the president can just blow right by, right, all of that and say there's no real lever on me. And it's not just about a federal government, right? So today, the median American lives in a state of about 10 million people. And in a state of 10 million people, governors are not elected or re-elected because they did or didn't fire, some officer in the county over there. So there might be good reasons to give the governor the power to remove officers at will, right? Reasons for like how the governor gets to direct policy and all those sorts of things. But the idea that it's a mechanism of a political accountability all the way back to the people, and that's what it stands on, not so sure, right? So now you might disagree with all of this, right? In which case there's an opportunity for you to make an argument about that. If you agree with it, and if you find that you think the ratifiers nonetheless were investing in this, it's an opportunity for you to do the following thing, if you want. One of the standard criticisms of a lot of originalist scholarship is, it turns out when you read this originalist scholarship that the founders thought that the best way to run a government is also the way the author thinks would be the best way to run a government, right? Fancy that. When you come to a point and say, you know what, I think they thought this, and I don't think it works. It's an opportunity not to, don't run away from that, right? Lean into that, because it's a way of establishing the bona fides of your originalist scholarship.
Thank you both very, very much. Richard, I appreciate especially that last comment about how to lean into ways in which I think it doesn't really work all that well. As far, and your point about removal might be a way in which I'm right now actually in a misleading way packaging this that tries to tie too far back to the officer accountability piece or the officers of the United States piece that I wrote before. Because I do think that that the issue of electoral accountability was going on to a degree with appointments and removal, but actually when you're reading through the ratification debates, or when I was reading through them, a lot of times the discussion of the accountability coming from elections is coming up in terms of discussions about the House of Representatives, who would have been representing obviously a much smaller group of people than the president, up for re-election every 2 years. And where I think that's meaningful, perhaps in modern debates, is the reason why they thought that was going to actually be a valid mechanism is because they thought most of the power, particularly domestically policy power, was going to be exercised primarily in the House. And so I think it has something to say about the distribution of power. I mean, there's even discussions about how the House holds a large share of power, the Senate less, and then the president least of all. And so I think the frequency of the elections and the large share of power of the House is why they thought it was going to, in general, there was going to be an accountability mechanism there where if the House of Representatives were just enacting oppressive policy after oppressive policy, high taxes, all of these things, they were going to find themselves having to have a lot of explaining to do back with their local constituents. And at least in my view, that seems to be a lot more of a likely, directly effective thing than talking about one of many decisions made by one person who's representing who's elected by the entire country. And I think it just shows which branch of government we thought was going to exercise the most power. The other thing about your point about the supporters and the opponents, and maybe I'm putting this back on you with a question. What the right way is to handle that in this piece, like if I need to just acknowledge when I'm talking about comments made by an opponent of the Constitution, or maybe people just know that Patrick Henry opposed it. But then I also want to push back, because you say Patrick Henry has a starring role, which he does, because he has sometimes views that not everybody is at least communicating quite as directly or starkly as he is. But I mean, is it actually correct to say, I mean, in a certain sense, he did lose, yet even the losers had an impact, right? In the sense that a lot of what the losers wanted and what was really bothering the losers is that we didn't have a Bill of Rights, and lo and behold, we get one. A couple of years later. So I don't want to just throw all of that out. I mean, I think the whole discussion sort of had an impact in terms of, we still, even with these concerns and these statements, the Constitution was ratified, and just because somebody opposed the Constitution doesn't necessarily mean that they had a misunderstanding of what it was going to accomplish. So I don't know. Do you have thoughts on whether, are you meaning to say I should just dial it down in terms of not focus so much on the opponents, or just be clearer about who was on what side?
I mean, at the risk of a second bite, because I'm being asked the question, I think it's super complicated, right? I think it's a long discussion about method, and I think the first question to answer is, what's the goal of the analysis, right? If you're trying to paint a complex picture that like renders thickly the range of ideas about accountability that are on offer, then yeah, show me Patrick Henry, show me everybody, right? And give me some sense of like how many think who to the extent that you can, with due caveats and so forth. But that's not the kind of analysis out of which you're likely to get like payoffs about how representation ought to work, right? It's a different sort of enterprise. If you're trying to answer a different question, if you're trying to answer a question like what is the best constructed understanding on something like an OPM model or some other model of originalism, right? For like this legal achievements theory of some piece of accountability, then you need to make a bunch of other choices that I'm not gonna be able to well, you understand what follows from that, right?
Thank you. And Larry, thank you for your point. And maybe I need to even fiddle with the title, because I think where the state officers is coming up is the larger idea of governmental accountability in general, and the structural mechanisms that were put into place to be sure that the federal government or the federal actors did not overwhelm and did not oppress. And so the idea was that if there are fewer of them, and we give things to the states, then we just don't have these people. So in other words, it was not an individual accountability point. It was more, how is the federal government going to be accountable? Some thought just have it do fewer things by it passing laws and it using this already pre-existing body of officers, so we didn't have more government officers running around. And it was also Madison. I'm not sure he talked about it as much in the ratification debates. I think it was Federalist essays where he wrote about it, but he definitely wrote about it. He definitely believed that it was going to be the case that it was going to be state officers collecting taxes, and then starts to propose that as the mechanism for collection in the first congressional debates when they start talking about customs laws. So that was not a view that I don't think people would have thought it was wacky. It may have just been a couple of influential people who talked about it, or people who we might think were reasonable, but it didn't obviously end up carrying the day.
So it's really easy for us from the sidelines to take advantage of people like you by saying, here's something else I'd like to know a lot more about. But here's something else I'd like to know a lot more about, which is accountability mechanisms for military officers. I've been having some conversations with Zach Price, whom I see was one of the commentators on your paper, about the standing army, and the interesting fact that army officers and soldiers as well had an accountability mechanism that was criminal. That is, if they disobeyed orders, they could be flogged or hung or kicked out of the military or thrown in the brig or whatever. Unlike civil officers, for whom disobeying their superiors is not a crime. So I think that's interesting, and it corresponds with the fact that, or it might or might not have any relation to the fact that military officers and soldiers are protected by courts martial, and therefore the removal power doesn't directly apply. That is, certainly there's not at-will removal by the president, and that seems interesting. And I wondered if there's any discussion of that anywhere, because I just made that up. But it seems logical, and I just wondered if there was any discussion of it. But throw in the militia too. I know there was extensive discussion of the militia clauses at the Virginia ratifying convention, and there the accountability mechanism is really fascinating, because the officers are chosen by the states, but then when they become subject to the president as commander-in-chief only when called into active service. So it's a really carefully calibrated, partly federal, partly national scheme, and I would think that there must have been discussion at places like Virginia about the sort of political theory implications of that, but I'd just like to know more.
It might be interesting to have a national referendum on whether flogging should be reintroduced for government officers. I'm not sure how the referendum would come out. Ethan.
I struggle a little bit with the organization of the paper, and so I thought, what would be ways to kind of make it maybe a little easier on the reader to appreciate the work. And so one thing that I thought would be productive for you as you think about revisions is to not just think about singular mechanisms, that sometimes the paper just sort of reads like a list, and it seems to me, I mean, I appreciated what Will was trying to do in the beginning with the buckets, but to me what's most interesting about the buckets is that really there are packages of mechanisms, right? What the menu is not, you pick one mechanism here, one mechanism there, and a third mechanism from somewhere else, but that there are, to use some language from earlier today, there are clusters of these mechanisms, and they appear in different types of officer settings. And I just feel like that's what you should be showing us, is the way they work together, not how they work separately. So, you might have elections and bonds subject to impeachment. You might have bonds, forfeiture, oaths, civil actions. You might have salarization, no bonds. So in the president, we have no bonds, but we have salarization, which in part works, at least in our paper, with the oath, and you have impeachment. And what are these packages telling us about the way accountability works? Because they're not just kind of picked off the rack separately, they're picked off as a suite. And then the second thing I think would be useful to disentangle is sort of when it seemed like there was a presumption about mechanisms of accountability that were going to work in a statutory dimension, and when they were going to really work at the constitutional level, because I think the paper really runs the two things together too much. And the first thing that Congress does, statute 1, after they do a bunch of things about trade, they start setting up oaths for a variety of different officers. So why? And they didn't put those in the Constitution, and there was some reason that they believed that lots of mechanisms could work just at the statutory level rather than the constitutional level. And I think you want to tell us a story about the constitutional side of things, but if there was a presumption that there was going to be lots of statutory help for the mechanisms of accountability, it just seems like your paper could do more to help us wade through that.
Shakira.
So I want to congratulate you on the Stanford piece and on the development of this piece. It's nice to know that there's strong scholarship by female authors in this area. So I'm a little bit struggling a little bit with some of the premises of the paper, particularly this idea that there was this strong desire to protect individual liberty. And what I'm struggling with is the lack of any remedies in the Constitution for those violations, except for the Fifth Amendment, right? That one's clearly, you take the property, you pay just compensation. And despite all what all those different terms mean, at least when you read the Fifth Amendment that there's some remedy. And I guess what I'm really wondering is, and I think about this in the context that we have framers who are attempting to create a system of government that, as part of its core, some people can have no accountability for how they treat other people, right? And I wonder if that's part of maybe the tension that's missing in the piece, right? Is that on some level, I can't help but to fear like the framers fear everyone but themselves, right? So they want all this accountability for all of these ghost bad actors. But on some level, personally, they believe that they won't be the ones violating the Constitution. And of course, but the bigger thing is just if freedom of speech is so important, then why is there no remedy in the First Amendment for it? The same thing with the Fourth Amendment. If it's so important, why doesn't the amendment itself tell you what happened? And I guess I just wonder, is there just that inherent tension with coming up with the remedy? Because part of also what is happening is that we're negotiating the ability to own people and strip them of their liberty. And maybe those two things are just so incompatible in some ways, what the framers were trying to do, that coming up with the remedy sort of maybe would have taken them down a path that the whole process could have suffered. So I just wonder about that. I don't know if if that question makes sense for the piece, but it always, as someone who teaches First Amendment, individual rights, and criminal procedure, that's a big part of what we talk about, is just a lack of any remedies here. But yet these rights are supposed to be so important.
Jennifer?
So I appreciate all those comments, and I will try to think about those as I'm revising. And I probably almost certainly right now I'm too casually throwing out the idea of liberty being one of the main purposes. So at a minimum, need to probably provide more evidence of that, and also just think through the question about remedies and why there wouldn't be more specific discussion of mechanisms. And maybe I need to do more to highlight. I mean, if I'm going to make the claim that the mechanism was voting people out of office, do more to highlight exactly how that would, how that would work. And perhaps as I, go back and give more discussion, like others have talked about with the common law liability mechanisms as well, some of that will come more to the forefront. So I appreciate that. Ethan, thank you very much for the organizational suggestions. I do think that makes a lot of sense to try to think about how things fall together in clusters, and the issue of being more precise about when there seemed to be an idea that the Constitution itself was going to have an inherent mechanism, and when it seemed like there was just an assumption that there was going to be statutory mechanisms put into place. And Michael, I think that's a very interesting point about the difference between military officers and civil officers, and the protection by court-martial and inability to remove. And so I will, and also the militia clause, and go back actually through my notes, and as I look through more of the debates, try to keep an open mind and be sure that I'm not too narrowly thinking about accountability, because perhaps there's definitely extensive discussion, as you say, about the militias, and perhaps there's more there that would be relevant to the civil officer liability than I noticed when I made the first pass through the evidence. So I appreciate your question.
So if I can jump back on, I have a couple more thoughts that have emerged actually from several other people's suggestions. So one, another striking absence, which I think some of us will take for granted, but should be striking to some, is the absence of federal judges in the federal judiciary in the picture. In
my discussion?
And I think probably in the ratification discussion. I think I'm not a judicial review skeptic, and nobody should be, but I think it's probably interesting and correct that it's not like the frontline response to accountability is, don't worry, we're also creating federal courts, and they'll keep an eye on everybody. Whereas now, so much of our obsession in the modern light about remedies for government officers, we think about what are the federal courts going to do about it, and is there a way they can do something about it, and how is it going to work? So if you think about sort of things that have massively shifted, there's been a sort of tectonic shift in our thinking about accountability and who's in charge of it that's very different from there. So I think you could take that in multiple directions, including Richard's, to say, maybe they were wrong and we're right now, and the federal courts really are the right place to do it. I don't know. When you look around at the federal courts, maybe you think the other. But I think that's just a striking thing that's worth sort of calling an absence that's calling people's attention. The other thing that I thought of, also building on some of Richard and Jonathan's comments, was The size of the House. So you think about the accountability, this accountability issue of electoral accountability, and the House already has this problem that each member is going to represent a ton of people, and so how much can they really be tied to their constituents? And now they represent 10 times as many people, more than that, than they used to. So that accountability problem has gotten so much worse. And of course, one of the constitutional amendments that Madison proposes along with the Bill of Rights that's important to a lot of the states is a constitutional amendment to solve that problem by requiring the size of the House to vary as the population increases, to make sure we don't get too far away from this already kind of mediocre accountability we have. And I wonder if that should be, this is another example that might be an anachronism. So if we take their theory of accountability seriously, maybe we really need something like that constitutional amendment to keep the House even vaguely democratically accountable on their terms. Now, maybe we don't want to do that because the House would be even more unruly than it is now, and C-SPAN would be even less watchable or something. But if we don't want to do that, then again we'd see another sort of way in which their theory of accountability doesn't necessarily work. But it's an interesting, again, sort of anachronistic piece that we don't care about that kind of thing, but it was very important to them, and made it to Madison at the same line as the Takings Clause in the Fourth Amendment, and also the House. So those might be worth bringing in somewhere.
Which brings us accountably to the end of the session, exactly on time. So enormous thanks to all, and especially to Jennifer and to Will, with great gratitude for terrific papers and terrific questions and comments. Thank you.